So today I want to focus on two things. Firstly, the Lighthouse Project, which some of you may have heard of, and secondly, co-location of police and child welfare authorities. So the Lighthouse Project has been piloted in 3 sites, Brisbane, Adelaide and Parramatta, and is soon to be rolled out to 12 other registries. It uses risk screening, which parents can complete via an online application at the time of filing a parenting-only application to find the most appropriate case management pathway for the case. So it uses a traffic light type system of high, medium and low to decide which is the most appropriate case management pathway. So this is quite different for our court because in the past, as you know, people filed and you were on the same sort of trajectory regardless of what the level of risk was in your case. So screening is voluntary. Some people might not feel safe to disclose, but if there are many prompts to try and encourage people to complete that screen. The Family Law Act was amended to make risk screening confidential and inadmissible, meaning it can't be used in the proceedings because we wanted people to feel safe to disclose information in the risk screen without the fear that that would be used against them. So just in terms of the numbers involved, 60% of cases screen high, about 17% medium, and it's important to say they can still be very high risk cases, and 23% screen low. So the low risk cases are referred to early dispute resolution because we want those people to have an opportunity to resolve their issues and move out of the system before their issues escalate. We've learnt a lot about our litigant population through this project. Because that screening is confidential and inadmissible, we capture more information which can be used in court through the Notice of Child Abuse, Family Violence and Risk. And that's where people are disclosing themselves what sort of risks their children and they are experiencing. And I thought you might be interested in that. So during a 1-year period, 18,300 notices were filed. 54% of parties said a child had been abused or was at risk of abuse. 64% of parties said that they had experienced family violence. 57% of parties said that their children had experienced family violence. 39% said that drugs, alcohol or substance misuse was an issue. 40% said that there were mental health issues which could cause harm to a child. 26% said a child was at risk of being abducted, and 14% said that there'd been a recent threat to harm a child. So of those 60% of cases in that highest risk category, they have 4 or more risks. So we're talking about families with very complex needs. Those families are placed on a special list called the EVIT list. And really carefully case manage to try and make sure that we have the information that we need from the police, from the Child Welfare Authority, from subpoenas, because what we're trying to do is to allocate the resources based on the level of risk in the case. So these are the cases where an ICL will be ordered, where there'll be a child impact report, and we'll have involvement from the Child Welfare Authority, and the police get information through Section 69 ZW, or where it's really urgent, we can arrange for a representative from the Child Welfare Authority, so that's the co-located worker, to actually come into the court and provide us with a summary. And that's really important because in our court, there are often those contested allegations of violence, so each parent saying that they've experienced violence from the other parent. What we're trying to do is understand the dynamic in the family, to understand who's the most in need of protection. And those records from the police and the Child Welfare Authority can be really, really helpful in understanding the family's history and the needs of those children.
Thank you, Lisa. And I'll encourage you to ask questions through the app during the session, and we'll have this as a bit of an interactive session. Really interesting to hear about the developments in the courts, Lisa. And Daryl, I know that you've had a significant interest over many years in relation to interfaces, overlaps and gaps in systems. So I'm just interested to hear your thoughts on the challenges and whether you're aware of any solutions that are emerging at the moment.
Yeah, thanks, Ray. And as you know, we wrote together about Mind the Gap, the fact that there is some really significant gaps in the systems between family law and child protection. I mean, my background, I haven't come from a family law background. I'm mainly child abuse and neglect, child protection, and having worked for a number of years at the Australian Institute of Family Studies, where there's a strong focus around, family law issues, understanding the complexity and the ways in which those systems both intersect, but also how there are gaps remaining, was shocking to me. And I think one of the biggest gaps, that even though there is overlapping responsibilities and what seems like, overlapping desire to be able to identify risk and to be able to ensure the safety of children, certainly, the legislative obligation, the responsibility of both of those systems require that, there's still some major gaps. And the gap that I really see is about investigation. That the responsibility of state child protection departments, is to respond largely to mandatory reports, about risk of harm. And many of the circumstances that come to the attention of a family court don't meet the threshold. So even if they are investigated, it's not substantiated, often because of incredibly high workloads with the statutory child protection departments, it doesn't even get investigated. And so there's a range of different kind of systems for dealing with this. I was involved with evaluating Magellan, which was a case listing model within the family court to deal with sexual abuse and serious physical abuse cases. But there's a whole range of problems that it was trying to solve, made some headway towards that, but I think still remain. Clearly, and Lisa, I think it goes to the issue that you raised about the, I don't know if it's called Form 4, but that form, the notification of risk, that often parties, parents who are separated and arguing over, where children can be cared for safely, don't necessarily clearly identify the full range of harms, or in fact raise it at all. And it's hard to know whether that's because parents are deliberately holding back, whether they're fearful, or in fact whether they're not being well advised from their lawyers around what their responsibilities are. So there's a gap from that system perspective in even knowing what the concerns are. Then from the other side, the Magellan model was trying to bring forward those investigations so that state and territory child protection departments would agree, even though it looked like it wouldn't necessarily meet their criteria, to conduct an investigation. Most cases that are going through the court system, though, don't end up in the Magellan listing, even if they involve child abuse allegations. So most are going through, the Federal Circuit Court, or not being listed in that, partly because that notice of risk doesn't necessarily flag early on that this is actually a key feature of the case. But coming to the biggest gap that I wanted to kind of put out there, and I'd love to hear from my colleagues here whether they think this is even sensible, is that we don't have an independent system that actually measures capability of parents, who is able to do a good job of parenting and care safely for their children. Child protection departments, that's not their responsibility. They're saying, do you meet the criteria for effectively child removal? That's the end point of a child protection investigation. There might be a number of stages along the way to try and keep children safe, such as referring to a parenting program, etc. But if you're substantiating harm and the harm is high risk enough, then the tool that a child protection department has is to remove. So the skill set and the orientation of child protection workers is not to be doing a broad scale evaluation of parenting styles, parenting capacity, who's able to be most responsive to children. Are both parents capable of doing that? Or under what circumstances might there be some concerns in the context of parents who might be separating? And similarly, I think family court systems don't really have that in-depth capability of doing it. Although I think, you know, Lisa, from what you're saying, there's some moves towards that with the kind of pilots that you're talking about. But to me, the big gap is an independent system of both of those two structural systems, of the family court system and the child protection system, where you can go to have an independent parenting assessment. It kind of sounds a little bit like the, you know, the family relationship centres as they were originally envisaged.
Thank you, Daryl. So Anne, we're talking systems and children. What are your thoughts about these issues?
Well, look, I'm going to try, I'm actually going to read some of my notes, if that's all right. I've just come off another panel where we were talking about the voice of the child, and I'm going to try and not repeat that. But if anyone's got an interest in how we elevate the voice of children across these systems, very happy to talk about that as well. Can I just say, you know, firstly to commend the work that you've done, Lisa, and your colleagues, and the efforts that the court has made to try to integrate across the systems that, you know, with domestic violence and child protection and so forth. But also to highlight that in, you know, even the idea of a lighthouse, it's sort of like it stands out. This is an exception. It's an exception in a world where children and their needs and the needs of families are not really at the centre of how policies and systems are designed. And I wanted to refer to the fact that we currently have 12 plus national strategies in this country that are trying to improve the lives of kids and their families, and there's more across the jurisdictions, of course. And in particular, and they're all being done in their silos, in their portfolio silos, of course, and that children are now recognised as victim survivors in their own right in the national plan, but it's in the intersection between that plan, the national plan for ending violence against women and children, and the national framework for protecting Australia's children, and the national strategy for preventing and responding to child sexual abuse in particular. Those three strategies, this, I think, needs our very close attention, because it's at the intersections of these plans, that's where children and young people live. And it's through the gaps between these systems that children fall, because they are invisible and they are not heard. And we now know, of course, that domestic and family violence is not just something that affects adults, and we also know that it often doesn't stop when the adults are no longer in the same house. There are complex reasons why the well-being of children is not a national priority. I'm just making the case that it's not. And that's actually the biggest gap, because what we're doing is trying to retrofit systems that were designed for other purposes, not actually to meet the needs of kids and their families. The reasons go to the fact that historically kids have been seen as the possessions of their parents without rights of their own. And even now, you know, the role of government is really unclear. You know, I mean, I think I can say publicly that, you know, people in the former government actually said to me, it is not the role of government, you know, that parents raise children and government should keep away, right? And, you know, I think we don't have a really good picture of what is the role of government when it comes to looking after kids. It's sort of maybe stepping in at the last minute when there's harm, but there's not that sense of promoting well-being that is enshrined in the Convention. The idea that laws and policies and institutional behaviours are affecting children in their own right just isn't part of our lexicon, because we actually see kids as just an appendage of the family, and that children and policy, really we're not used to seeing them in the same sentence. And of course, when it comes to child safety risks, we now know that children who are silenced are not protected. So, you know, these are things that we've been learning about that show the failure of our systems. Let me just say a little bit, if I might, about systems change, simply because often these terms are used and not well defined. And so what I would call a system is the laws, policies, practices, people, values, power structures, and importantly the money that determine how things get done. And education is an example of a system that's meant to meet the community's needs for education, child development and training at the tertiary level. By the way, really good example this morning of a big systems change moment when you've got big states of New South Wales and Victoria jointly saying they're going to do something quite remarkable in the preschool years. Watch that space. So that's an example of a systems change moment that you don't see very often. So so we have all these systems. They don't work well together. Of course, we have the justice system, which includes the family law system, and then there's the child protection system. That's the one that's meant to step in when the other systems have failed to keep children safe. And of course, we know the child protection system is chronically overwhelmed because it's the failure of the other systems, health, education, social services, etc. Upstream, they're failing, so you basically end up downstream with the child protection system. Domestic and family violence, mental ill health, basic needs like income security and affordable housing. These are the issues that kids and families tell us about when we bother to ask them. These are the barriers for keeping children safe and well, right? The basic systems that are meant to be looking after all of us are failing the kids and families who are living with the most disadvantage. System change involves recognising that children and their families don't live in one policy silo. Our lives are complex and we all need these systems to work well together and to be coordinated. And the more complex our needs are, the more the fragmentation of systems are failing us. Most of us manage fine to navigate them when things are going okay. But once you start to pile on a few issues in your family, you find these systems are broken. The more needs you have, the more evident the systems are not designed to meet our needs as the consumer. Their design principles are based on other criteria. And if you're living with poverty, disadvantage, disability or other special needs, these systems are not working for you. So we need to start listening to kids and families. We need to address those elements I listed before, like the power structures, the values that underpin the systems. We need to examine ourselves and our own beliefs and behaviour, because it's entirely possible that the way we're behaving is inadvertently helping to keep things the same. However, and I'll finish up on this, Ray, child safety and well-being is not a system. It's an objective. It's a value. It's our responsibility under the Convention on the Rights of the Child, and child safety and well-being should be our national priority, but it's not. All policy and service systems should have child safety and well-being as a core objective that they're accountable for. And this includes systems primarily focused on adults, such as domestic and family violence, adult mental health, drug and alcohol, justice and prisons. These systems, they need to at least know their clients are parents. We don't count them when they're in prison as parents. They need to recognise and support them with their parenting responsibilities. The job of protecting children is not the job of the child protection system alone. The evidence is clear. There'll never be enough ambulances at the bottom of the cliff. I was one of those child protection frontline workers early, right at the start of my career. And I can tell you the amount of change in 40 years is minuscule. If anything, the job has just got harder. So, of course, we need change within that child protection system. We can talk about that if we want. But none of that change, the workforce development, the applying the Aboriginal and Torres Strait Islander child placement principles, the getting the workers away from their desks and out into the field. None of that's going to be enough because the child protection system alone cannot keep kids safe. That's why talking about the intersection of the systems is where the conversation needs to go. The core system's failure is the fact that child safety is siloed there, and we're not listening to kids and families about the upstream reform to those systems where most of our money goes, health and education in particular. That's where we need, that's what innovation should look like. That's what reform should look like, upstream. And we should stop tinkering around the edges. I call it managerialism, not leadership, where we're just looking at the symptoms of stuff, we're not getting to the underlying drivers and causes. I'll stop there.
Thank you, Anne. Very, very powerful points you make there. So Jess, you've spoken to a lot of victim survivors in your work as a journalist investigating family and domestic violence. What do you hear from those women, primarily, about how the systems meet or don't meet their needs?
So predominantly I hear from parents and grandparents and extended relatives who are desperate almost to the point of insanity. They contact me daily asking for advice on how to get a lawyer who will listen to them, what they can do about a family report that's just wrongly diagnosed them as having borderline, what they can do about the fact that because they brought child sexual abuse allegations to the family court, they're about to have contact removed. I remember when I spoke to Rosie Batty for the first time in 2015, she said to me, if it weren't for the family court, I almost would not get contacted by victim survivors. And I kind of know what she means by that now. Because I'd say, 60 to 70% of my contacts are about family court. And the fact that they're contacting me as a journalist shows you how dire the need is and how little services there are that are adequate to meet their needs. So the thing for me, I guess, is that we have a court system that has evolved, particularly over the last 20 years, to be decidedly pro-contact. Helen Rhodes has written so well about this. It's a culture that is replicated in many international jurisdictions, including the UK, where there is a very hot conversation going on at the moment about that culture and how dangerous it is for children. So we have a pro-contact court, and yet we have a court for which the majority of cases involve at least allegations of family violence. So we have a court that is a frontline child protection response service that is pro-contact. So let's just wrap our heads around how that works as a paradigm. Laurie Maloney's in the audience today, and I just want to credit him for an incredible study that he and her colleagues did last year on allegations of child sexual abuse that were put in front of the court. Now they found that 86% of child sex abuse allegations, I think between 2012 and 2019, were unfounded by a judge. In two-thirds of those cases, the care was increased with the allegedly unsafe parent, and in 17% of the cases, the contact was switched entirely, so to the allegedly unsafe parent. Now, that had a real particular resonance for me because in 2015, when I first started reporting on the family court, I interviewed an expert report writer, Chris Rickard-Bell, who rather candidly explained to me his method of assessing families. He said he'd assessed 2,500 families in his career. He does a lot of report writing for legal aid, so he does it at a reduced cost, which is still extremely expensive. And he said that in 90% of cases of child sexual abuse allegations, he found them to be unfounded. Now, when I heard that, my spidey senses went up pretty quickly, just that, wow, I mean, as a journalist, I was both horrified and also awed by the fact that he had told me this so candidly and on tape. I thought that he'd made a mistake in telling me that. When the report went to air, there was, you know, widespread horror. His name was raised in Senate estimates as somebody who should not be writing reports. He actually threatened to sue me if I included that quote in my book. And when I went back to him with the transcript of what he said, which he clearly said those things, we published a book and lo and behold, he never sued. I tell that long story to say that people were alarmed to hear that he unfounded 90% of allegations as a report writer, and yet that is essentially the statistic across the family law courts. Now, child sex abuse, any type of sexual offending in any courts is difficult to prove. Obviously, there's a different level of proof required in the family courts. We're talking about risk, not talking about convicting somebody. Rape convictions are very low. But imagine if your rape you got a not guilty verdict in your rape case, and then you were ordered to live with your rapist. And I'm sorry to be really blunt. Nothing freaks me out as much as the family law courts, to be frank, because what we have is almost a 19th century system in which children, some of which have been very active in the decision to leave, who have advised their victim parent to leave, and been very courageous in the act of leaving, are being ordered by courts to return to that parent into unsupervised care or into sole custody, to use an old term. I've been waiting since 2015, and I know that many people in this room have been waiting probably for a lot longer for this to be a nationwide scandal. And I think it's just a matter of time before it is. Kids are not going to remain silent about this forever, and no amount of Section 121 prohibiting, you know, parties from being identified is going to stop some kids eventually from reaching the media, whether it be me or whether it be somebody else. And when people read my book, that like almost to a person will say the chapter on the family law courts blew their minds. They could not believe that this could be happening in a modern court system. Now, there have been amazing improvements. The Lighthouse Project is an incredible improvement. The training with the Safe and Together Institute, which is, I think, one of the best educational teams in the world, is an amazing improvement. Mapping of perpetrator patterns and impact on children and families is such a great improvement. But we are dealing with this in this slow motion way, and it is an urgent problem. This is not something that, you know, an Attorney General can just make a nice piece of reform to leave a legacy. This is something that is the Attorney General should feel is an absolute matter of compelling urgency, because it is a matter of time before the government is going to have to apologise to the children who were forced to live with their abusers. That is a matter of time, and there are, you know, several people who've been calling for a royal commission into the courts because of the lack of transparency and accountability. Whether we get to that point or not, I don't know. But, you know, there's lots that we could say about how things are going wrong, where the intersecting systems are going wrong, but I just want to land that sense of urgency that today, tomorrow, the next day, children who have been encouraged to disclose their abuse, children who have been courageous in helping their victim parent leave, are going to be ordered into the care of an abusive parent. And just think about that child and their victim parent and think, how much time do we have to address this?
Okay, so some very interesting points have been made. There's the iPad has spat the dummy and disappeared, but there were some questions that did come through the iPad before it did that, and fortunately I remember what they are, so I'll ask them. So one of them, Lisa, is directed to you. It's from Robin Clough from FRSA, and Robin's interested to know in relation to the Lighthouse program whether or not it will kind of be extended beyond a screening tool, and then, you know, an evidence gathering, you know, the wider program, into a kind of a referral sort of process to assist people to address the underlying issues in their matters.
Thanks, that's a great question, something I probably didn't explain very well at the beginning. If you screen high, remembering that both parents or can screen, you are referred to a family counsellor. That session's confidential, and it has two purposes: safety planning and service referral. So by way of example, if you identified via the screen that you had an issue with substance misuse, you'd be referred to a service to assist you with that. So what we wanted, this is the public health aspect of the program, we wanted people to feel that they could disclose their issues and get some assistance without having that used against them. One of the things that we were surprised by is that we thought that a lot of the referrals we made would be to domestic violence services, and yet a lot of the families we're dealing with actually have already had contact and do have the support of the domestic violence service. But it gives us the ability, or the family counsellors who work there, to make urgent referrals, for example, to police for people who need really urgent safety, and to other services, housing services, etc., that can assist them. So that is a key part of the project.
Right, thank you, Lisa. And then there was another question from Rebecca Giles that was directed to Jess, and she was interested in Jess explaining more about the comment that you make in the opening of your book in relation to using the term domestic abuse instead of domestic and family violence.
Yeah, sure. Look, it's a it's a personal choice, you know, and I think that, like, I certainly wouldn't say that other terms are wrong, or that, you know, because everyone's got kind of their reasons for, you know, holding on to the term of violence, for example, and trying to reinterpret that. My reason really was underpinned by the sheer number of victim survivors who would say, how are you going to explain that for me, that the physical violence wasn't necessarily the worst part? Like, how are you going to put it on an equal par with all of the other stuff? And what they're talking about really is the coercive control. And I never had a good explanation for it. And then I was reading this article by Yasmin Khan, who runs community services group for South Asian women in Queensland. And she wrote in Women's Agenda that, you know, that all these women would come in and they would describe these horrible campaigns of control, but they'd say it's not domestic violence because he never hit me. And she did a Churchill Fellowship around the world and found that, you know, in the UK particularly, they've progressed to using the term domestic abuse, because in the UK and since 2015 in England and Wales particularly, they've criminalised coercive control, and there's been more of a process towards changing the pyramid, or where physical harm is put up the top, flattening that to show that physical harm, sexual harm, they're all just tools. They're all just a means to an end. And we've focused for so long on the abuse or the violence, we've focused for so long on incidents, and even though we've also looked at the various different ways in which different abuses can be combined, what we haven't seen and really, well, not what we haven't communicated, is that abuse is just a means to an end. And in a lot of these situations, the end is entrapment. So abuse is just a function, and it might be physical violence, it might be financial abuse, it might be spiritual abuse. It doesn't really matter. It's about the correlation of those and how they're used to entrap. And so I thought, well, since the UK has moved on to use that term, and because it has opened up conversations like this, practically every interview I've done has almost always started with, so why do you use the term domestic abuse? And it opens up this whole conversation. So that's why I did it.
Okay, so I'm just wondering what the other panellists think about the points that have just been made.
Can I just share a little anecdote? So it just reminded me of this, I spent a lot of my career in frontline practice working in domestic violence and then sort of moved away from that. But I remember in more recent years, a young woman coming to me and telling me a story about her friend. And she wanted to know, she wanted some advice, and she said, and so she would have been like 23 or something. And she said, my friend is in this relationship and her partner got angry and he picked up the laptop and chucked it across the room. Not at her or anything like that. Is that a problem? Like she was genuinely asking me whether that was something that she should be worried about. And it just really told me that for so long, with the very best of intentions, the domestic violence field, which I've been part of, really has not resonated with particularly young people who don't see themselves as victims, and their understanding of what domestic abuse is, if we use that word. There's just been a lack of community understanding. And that story came into my mind as you were explaining why you use that term.
I think we also have similar challenges outside of the family court system, or even the domestic and family violence kind of sector. In the child protection sector, often there is a sense of horror around, rightly so, around child sexual abuse. We've had a Royal Commission into institutional responses to child sexual abuse. But often there's a great gaping silence, and this is one of the things that we're trying to address with the Australian Child Maltreatment Study, is to understand the prevalence of all forms of child abuse and neglect and the degree to which they overlap with each other, including domestic and family violence. And so, which I wanted to come back to you, Jess, actually, because when you're talking about the experience of women in particular within the family court system, do you think that part of that problem is that, as a society, but also, a system, where we're not really grappling with the full prevalence of all of the different types of harm that both adults in, relationships that are separating, but their children are likely to be subjected to. And therefore, we've kind of designed a system that actually isn't, dealing with a small little exception that's over there, but it's actually a big problem right across the community. Yeah.
Totally. And a lot of, it's weird now, predominantly I do public speaking more than I do journalism. And so a lot of when I do public speaking is I'll look at the stats, and you say 1 in 4 women, well, that's 2.3 million women. When you have some small studies showing as high as 1 in 4 children, a nationwide British study shows 1 in 5, so it's probably about right. That's 800,000 kids who are just kids now. Not to mention all the adults who have grown up with family violence. We don't even count the number of perpetrators. So before you get, anywhere, you can't, and of course there are men too who have experienced physical aggression of all kinds, and that's about 700,000 or 800,000 men. So before you get too far, you're up to 4 or 5 million people in Australia. So yes, I think we've thought about it as a niche issue, which it clearly is not. And I also think that, the conversation that's emerged around coercive control, which has very much been accelerated by the horrific family homicide of Hannah Clark and her 3 children by Rowan Baxter in Queensland in 2020. That is so important because we are quickly accelerating away from an incident-based understanding of domestic abuse to a pattern-based understanding of it. And Dr. Emma Katz in the UK, she's about to release a book on coercive control and the impacts on children. And you're seeing this more and more in CAFCAS, is the family report writer, body in the UK, and other analysis on kids, is that coercive control is as harmful to kids as direct physical or sexual abuse. And that kids aren't exposed to domestic violence. They don't just witness incidents. They don't just happen to be awake when they're pretending to be asleep. They are making sense of the oppressive environment they live in. They are targeted as a secondary target to the victim parent. They are enlisted as co-abusers sometimes. They are parentified, and they are doing that all in the formative years, you know, and the developmental trauma of coercive control is so severe. And as, you know, as has been said, like the coercive control, particularly in the family law system is involved, does not end with the relationship. And it carries on with children as proxies. So that's another big paradigm shift, I think, for the family law system, is to stop putting physical violence at the pointy end and start seeing the entire system of coercive control and how that, for some families, is the worst part.
And can I just pick up on that and ask you, Daryl, so with the ACMS, will we get visibility? So I've got this theory that actually kids themselves are experiencing coercive control much more than we think, and that's something we'll be talking about in the future. Well, is that something we'll get?
Yes,
we'll know.
we've got
Yeah.
a range of screeners around what we put in the category of both emotional abuse and also of exposure to domestic violence, and so that will cover a range of different harm types and from different people perpetrating that harm. And so the Australian Child Maltreatment Study will be able to give some, and I can tell you it will be mind-boggling data to answer exactly that question and put our focus back, as you say, on children and their experiences of living in families where toxic environments from a range of different sources and a range of different types are coming together. And I don't think we've got a system or systems that really is acknowledging and aware of the complexity and the frequency of it.
I think certainly the research that we've done with separated families over many years has, you know, very clearly demonstrated that children are directly exposed and directly affected, and that any child who grows up in a home where there's family violence is doing less well than children that don't. And obviously there's a lot of nuance in that, but, you know, the evidence base has been developing over many years. I might just see if anybody in the audience has a question that they'd like to ask of the panel. Yes, thank you.
Sorry, I just asked that question, which I understand the iPad, by the way. But I guess what I wanted to know in asking that question, and sorry to drag it out, but do you think it would be useful to change the terminology as far as, you know, discourse, advertising, government campaigns? Would that be a useful move to go towards the direction of what the UK has done, considering, like even in Daryl's study, you just differentiated domestic violence with emotional abuse? Would it be useful to change the terminology?
It would be really interesting to hear from victim survivors about whether they see themselves more readily in that term. I mean, a lot of people still won't see themselves in the term abuse because they conceptualise themselves as the strong person in the relationship who's actually helping someone who has a lot of problems, you know. I think it's not just about changing the term, although I think that's important because I think violence, you just can't get past it. Physical is the way people interpret it, even with all the work we've done to try to reinterpret that. But what I really like, and again, going to mention Scotland, which has been getting a star run today, they did a series of stock photos that were developed in conjunction with victim survivors to basically re-envisage what coercive control looks like. And it covered multiple ethnicities, multiple age groups, but most importantly did not have someone cowering in the corner below a raised fist. A lot of it was pictures of surveillance, of monitoring, of, you know, mothers comforting children, that sort of thing. Like I had a victim survivor say that in the midst of horrific family violence, she was in hospital, she went to hospital, she saw a domestic violence poster on the wall, and her initial thing was like, oh, that poor woman. Just did not see herself in that poster at all. Yeah. So I think it's like there's stuff to the terminology, but also to the portrayal, and how what kind of images we show of what coercive control, what family violence looks like.
I think we should change the terminology. I'm stumbling across it all the time when even things like it's sexual assault when you talk about adults, but it's child sexual abuse when it's kids. I mean, it just makes it impossible to really have the conversation with anybody that really, cuts through when everything is siloed in this way. So I think we've got a problem with language still. I probably need the mics.
Yeah.
Do we?
I think you actually need to, yes, you need
Yes,
to go
sorry.
over to the mic.
Otherwise the audience won't.
I'm from Relationships Australia in Tasmania. I'm a non-practicing lawyer working as an FDRP, and I see lots of, reports of all types of family violence. And I think it's fantastic that coercive control and its impacts has come to the fore. But what I wonder about with the move to criminalise it, whether there's a risk of taking it out of the family law jurisdiction where, because it is a form of child abuse and a parenting decision, it ought to sit.
Well, perhaps I should have raised this before when we were talking about definitions, but I think it's important to say that the Family Law Act talks about family violence, but it actually uses, so rather than domestic violence, which is often used in state legislation, but it actually talks about behaviour that coerces or controls a family member or causes them to be fearful. So not both, or they're alternatives. So coercive control is actually part of the definition in the Family Law Act. The other thing I'd like to say, having sat in the Evatt list for over a year and done so many of these high-risk cases, what I know, I agree wholeheartedly with what Jess said about the intention of using any one of those methods, whether it's sexual violence, physical violence, cyber stalking, any kind of harassment. Choose your method. It doesn't matter. They all have the one end, which is to control a person and generally the whole of the members of the family, including children. But what really, I think, surprised me doing that list is that the violence is horrific and it's multifaceted. So, extreme levels of violence of every type. Terrible name calling, just derogatory and awful, terrible physical violence, terrible sexual violence of adults and children, so choking children. And these aren't allegations. A lot of these things have been the subject of criminal proceedings in other courts, so we know that it's been found to have occurred to a criminal standard. And this is the work that we're seeing in the family courts at the moment.
Can I just add something to that? That is that in the UK, where it's been criminalised, what it's done is it's actually accelerated a conversation about coercive control and the seriousness with which it's treated in the family courts in a way that just wasn't happening before. And of course, we're a bit further along now because we're a bit further along than 2015. But I don't think, like child sexual abuse is illegal. Many of the other issues that come before the family law courts are a criminal matter, can be a criminal matter. Even if coercive control is criminalised, and it will be in Queensland and it probably will be in New South Wales, most of that is going to be dealt with in the civil courts anyway. What we see in jurisdictions where it is criminalised is you're seeing the very pointy end of coercive control. Most of the time there's physical violence, involved, but it's showing the entire pattern rather than just looking at one incident. So I don't think that it would be deleterious to how coercive control is dealt with in the family law arena. In most cases, you won't get criminal intervention, prior to. Just like at the moment, a lot of the cases that you'd be seeing, there may be some criminal intervention, but often probably not. Like often there's allegations that rise in the context of the family law case.
Look, in the list I do, the themes are many dads in jail for horrific violence, many dads out of jail having committed horrific violence, you know, people who've been found to a criminal standard of proof to have committed various criminal offences against children. So there's a mix, of course, you know, things that aren't criminalised, but there are a lot of matters that meet that criminal standard.
A very difficult caseload. Yes, we have a question.
Hi, my name's Kathy Oddie. I'm one of the hats I wear as a victim representative on the Victims of Crime Consultative Committee. And another reflection around this discussion that I'd like to put back is that many things, as victims of domestic abuse and sexual violence will know, our cases may never proceed to court. We may never get a conviction. However, under victims of crime, one of the things that has just been legislated is the new financial assistance scheme, which is going to take over from Victims of Crime Assistance Tribunal. And some of the key changes that are going to be taking place from the new scheme next year is that children will be recognised as victims in their own right, and also the importance of things being criminalised, such as coercive control, is currently under VOCAT. You can't even put in an application unless you've experienced sexual or physical violence. So to have those definitions extended to be more than just sexual or physical violence actually acknowledges those other harms. So whilst you might not get a conviction, by having that broader definition, it means you can actually have that opportunity to access different types of supports that acknowledge your harm and also to address ongoing healing from your trauma. Okay, so that's another bit that often doesn't get talked about, but it's really important to acknowledge.
That's right. It's probably also worth acknowledging that the Family Law Act since 2012 has recognised the significance of children's exposure to family violence. So it's recognised them directly as victims when they are exposed. So obviously these things are moving. They're moving along. It's a progression. But it's very interesting, the urgency that you're suggesting surrounds this, Jess. I'm just curious to see if anybody else in the audience would like to... you were standing at the... Right, got it.
It's Angela Lynch from Queensland Sexual Assault Network. I was interested in the types of evidence that the family court, and especially perhaps in the Lighthouse list, if it's looking at a broader range of evidence or not. In our network, there's counsellors, both they counsel children, women and men. And when I speak to children's counsellors, and often they're working, a lot of their caseload involves family law, or there's background issues in the family of family law. 30 to 40% of their caseload involves these families and this system. They're often working with the family, with the children, with the woman over a period of 2 years, and for a long period of time. And they often say their notes may be subpoenaed, but they're never spoken to. So I suppose their professional expertise, what they're seeing on a day-to-day basis, they may be seeing and working with these families, with these children on a weekly basis for 2 years, and they're not spoken to, and that's really common. And so therefore, the information that they may have, or that may be able to assist the court in relation to the court's decision-making, that's not part of the picture that takes place. And my kind of way I think that might happen is that there's this presumption that they're biased, they're a sexual violence service. And I just suppose I want to say that our counsellors are so overworked. Like if they felt that they were with a family that was not, didn't have these serious issues that were coming before them, they just do not have the time to be dealing with those. They've got caseloads of, 12, 15, 18 months waiting to get in. So I suppose I just wanted to, open up around whether the Lighthouse is looking at different kinds of evidence or just from that perspective around what evidence does go before the court.
Yeah, so one of the case management or the case management model that's used in Lighthouse is that the registrar starts case managing the case from the moment it comes into the list. So the intention is that when the interim hearing is held, it'll be a meaningful court event where all of the information that the decision maker needs will be before them. So ICLs, as I said, subpoena information. They might be the person who's subpoenaing the sort of records that Angela just spoke about, but the registrars actually make the orders saying issue a subpoena to this person, that person, the other person, to try and get a comprehensive suite of information to make the best possible decision. It's important to remember that a very small percentage of matters, I think about 3%, go to a final hearing, which may be one reason that someone's records are subpoenaed and they're never called to give evidence. One of the surprising things we found in Lighthouse that we hadn't expected is that our cases have a high settlement rate, and the emphasis isn't on settlement for the sake of settlement, it's on safe settlement. And we think that the reason that it's happening is because there's all this evidence really early, and that people have a more realistic understanding of the risk issues in the case and what safe options might look like. And there was a reference earlier today to the no contact orders. More no contact orders are made, I think, in the EVIT list, and dads are often agreeing to those.
And that's exactly the same finding from Magellan, years ago, that it's about getting the right information, the right assessments being done by the right people. Having that early information can mean that cases are more likely to resolve quickly and might resolve without the need for judicial determination. But I was also going to say to you, Jess, that there's only a small proportion of cases in the family law system that are actually coming to, for judicial determination. And so while we're seeing probably the most toxic and difficult end, I'm wondering, is that because it is so vastly different from the rest of people who are separating without the need for judicial determination? Or in fact, are there to varying degrees that same, maybe not quite as complex, not maybe as quite as violent, but are those same features going on out there in families that are choosing to separate on their own? And is the family court per se the right and the only option for dealing with this? Or do we actually need to have a new system, a new way of being able to support all families, including those who are going to separate? But I would argue, why not just start supporting all families?
Yeah, well, I think an adversarial process, in a child protection context is probably wrong-headed. As Anne was saying in the previous session, if we were to design this from scratch, would we really design it like this? Other members of the panel would be more well-versed on this, but anecdotally and from research, you can see that a lot of lawyers are advising victim parents with a very strong co-parenting stance. They're advising them to make consent orders and not to go to court. For some people, it's a costs issue or the fact that they just do not feel confident self-representing. So there's so many different factors that will go in where certain things are agreed to earlier, which the victim parent and the child feels is utterly unsafe. But they don't feel like they're going to get a better outcome in court, and in fact they feel they might get a worse outcome. That's what I hear commonly.
I think we might have time for one more question from the audience, if anyone is... Jess?
behind you.
Hi, thank you. Jessie Dunstan from the Australian Institute of Family Studies. Thank you so much for this. It's been amazing. Been really, really interesting. I have a couple of questions, and apologies that I haven't articulated them. I'm not going to articulate them very well because they're all swimming around in my head. Okay, my first question is that the red light cases in this, in the new system, with the referrals to services and to get further investigations, are there, where are the financial responsibilities coming from, the funding for the additional cases? And if we think about the cases that would be coming towards, before the courts, or just cases of these highly vulnerable families being, in many cases, quite disadvantaged, are there disincentives for them to be raising issues or being disclosing issues in the initial cases, in the initial assessments, where they're assigned a colour?
It's not really a colour.
No,
It's a traffic light.
No, I understand. I understand. This. Sorry, I was being facetious. Are there barriers for those families that are highly at risk?
Yeah, I think I
accessing
understand the question. So the first thing to say is it's not compulsory to screen. We deliberately made it optional, an opt-in system. The second thing to say is that with the safety planning and service referral, which is confidential, we didn't have funding to get new services. So people are referred to existing services. Remembering, look, yes, of course, it places strain, I'm sure, on those services, but we are talking about relatively low numbers of people. And that public health benefit was to try and give people an opportunity in a confidential way that wouldn't be used against them to address the issues that they've self-identified. So I think I said before, we were really surprised a lot of these families were already plugged into DV services, for example. They actually know what their issues are. It's giving them confidence, I think, often to know that if they use those services, it won't be used against them in the court, which is one of the fears that people have had traditionally, that they'll be cross-examined about seeking help.
I understand. I guess, and the other part of my question was, with these services such as expert report writers and ICLs, there are some suggestions that there is a small, maybe larger clutch, such as the Regard Bell type situations, where there's, despite the advances or the amendments that have been made to the Family Law Act to change the definitions and have them more legally reduce the or make it clearer what falls under the legal term definition of violence. That then, what's being done within the culture of these systems to actually change some long-held beliefs about, how you apply this. So, 90% of the child sexual abuse allegations are unfounded, and such cases with ICLs, or not asking particular services of their...
So Jess talked about that Safe and Together training, which all of the registrars and family consultants did. For those of you familiar with Safe and Together, which it was designed originally by David Mandel for the child protection system, but the focus is really on, as Jess said, trying to understand the dynamic rather than have an incident-based approach to violence, and also understanding that perpetrator mapping, how the perpetrator is using violence. I can see, when I look at those child impact reports, the difference it's made to the way that those reports articulate how violence is being used in that family. So I think it's very practical. It also provides an opportunity for children to explain their experience of violence. A lot of work's been done through the National Judicial College in training for judicial officers on family violence. The court has some absolutely fantastic modules which it's developed, which are very comprehensive training for court staff at every level. We do different amounts of training depending on the role, but they take for a registrar about 15 hours to complete, and everyone does it on orientation. There's the National DV Bench Book. There's a lot of work happening to try and provide support within that court system for people to understand violence better.
Can I just throw in one last thing on that? Safe and Together developed for the child protection system. How ironic that it's being applied in the family law system. So isn't that argument for a new joined up service that can be actually doing independent assessments separate from both systems, feeding into both, but also being able to adopt what you said before, Anne, about a more upstream prevention approach. I think if all of these systems of assessment are only focusing on the narrow, pointy end of those coming into contact with, whether it be a statutory child protection system or a family law system trying to make decision making, if you like, of where children are going to be safe, it's too little too late.